Today's court hearing dey important to all Biafras. Abeg make una share this video to everyone so that they go see wetin go on today, because everybody need to dey at alert of wetin dey go on, so that this time around make we get am right and see how government go just do their mago. So pay attention, listen to the court hearing and share this video to everyone on every social media platform. No forget to click the subscribe button for more updates.
Yes. Today being the 9th day of the month of March of 2026, as we dey speak to you, the Supreme Court, Abuja, don surprise Nnamdi Kanu with one of the biggest documents and one of the biggest court declarations. And in this video, we will do our best to critically analyze them and break them down for you step by step, so that even the old, the young, and the illiterate will still understand and pick one or two from this video. So how will it be? Well, permit me to use our illustrative software to explain. Showing right now on your screen our illustrative software, and when you look closely, you will see Nnamdi Kanu on the left hand side of your screen. We also have the appeal court right about here, and we have the Supreme Court right about here. The question now, where most of them will get, we say, how did Nnamdi Kanu, or why has he received surprising documents from the Supreme Court? The court will be say no really concern am as they speak. We all know say Nnamdi Kanu gets case. He don't file a case in the appeal court. So everybody's eyes should be on the appeal court. Why did he leave appeal court and then they focus on the Supreme Court? Make I explain. We know say Nnamdi Kanu happens to be one of the most intelligent personalities in Nigeria. Everything where Nnamdi Kanu don't talk has come to fruition one way or the other. And things will never come to fruition will come to fruition from tomorrow going forward. So for this man to tell you that, see you, I will go to the appeal court though, but then I dey plan ahead of time, I dey lay strategy, and I dey draw blueprints and formulate leads and method for the Supreme Court. You suppose know say he don't see the future before now. So why is Nnamdi Kanu now focusing on the Supreme Court, and which document has he received from this court, which is surprising? Make we break them down for you. We know say on the 24th day of the month of January of this particular year, the appeal court told Omotosho, says, we want shortlist you for the possible, we want add new personalities and new justices into the appeal court. So they can shortlist Omotosho into that particular list. Meaning say, if Nnamdi Kanu enter the appeal court, Omotosho go dey there, they wait for them. In this part, for this particular thing alone, Nnamdi Kanu know say all the judges in the appeal court will be friends with Omotosho, and they calculate say, make I dey plan ahead of time. I dey plan for the appeal court very well. I dey put all my very, very best into the appeal court. But at the same time, make I dey strategize for the Supreme Court. This is something a very smart and intelligent person would do. So how it be? Aloy Ejimakor don hint us before, say now the Supreme Court they wait for. He don hint us a couple of times. Say, I know say that they wait for appeal, but me, na Supreme Court, my mindset dey according to wetin Aloy don drop as of couple of weeks back. So wetin dey happen? As we dey speak now, the appeal court don drop two biggest documentations and two biggest declarations. One was dropped on the 30th day of the month of January 2026, while the other one was dropped on the 17th day of February 2026, 3 days after the infamous Valentine's Day. And again we say Nnamdi Kanu still they wait for, but you'll be very, very patient about it. Okay, so what do we have here? The very first document, or the very first declaration, we don't dey na mobile land compensation claim. Make I explain. This thing where they see right now on your screen, na two cases where the Supreme Court don't handle as of 2026. They don't handle two big cases, and very soon they go add. Make I draw a line so that we follow this video as it be. So these two cases where they don't handle them. That is this, and this has been handled. This other one is pending and is coming up very, very soon. Okay? Meaning say the Supreme Court don't give declarations on 2 cases in their courts. How does this affect, or how will this play a vital role in Mazi Nnamdi Kanu's case? Well, make I explain. Mazi Nnamdi Kanu has been waiting for this declaration because he wants to pick 1 or 2 rulings. We go come from here, package them, pad them, put inside his case file. Okay, let's go through them one after the other. As of the 30th day of the month of January of this year, the Supreme Court dismissed and nullified a long-running compensation claim of about 1.4 billion naira against Mobile Producing Nigeria Unlimited, which is now known as Saplat Energy, and others over land acquisition in Akwa Ibom. Okay, let's wipe off this thing and scroll up a little because information choke today. May you know it's Mazi Nnamdi Kanu they prepare and hide a package jam. Okay. The article continued by saying the court held that the Federal High Court lacked jurisdiction to hear land-related compensations claims, such as matters which fall under state High Court jurisdiction. Are you guys following? So they carry this particular case, enter the Supreme Court. They can't make a very strong statement. The Federal High Court lacked jurisdiction. How does this even concern the case of Mazi, and how he take the plan to use them to his favor in the next coming days? Okay, let me break it down for you to understand. So this particular issue between Mobile and a different entity was the first carry and enter the Federal High Court. They gave a decision in July of 2018. They still carry them, say no, we don't like your decision. They carry and enter the Court of Appeal, and the Court of Appeal still ruled in favor of Witty, the Federal High Court don't rule. Until these individuals carry the same case, enter the Supreme Court. Now the Supreme Court can say, no, you guys are not, you don't have jurisdiction to handle that case. So how it be? How is Mazi Nnamdi Kanu using this particular document? And how is this even surprising in his case? Now we too want to look at right about now. How does the case file help Nnamdi Kanu's issue as it be? Well, if you follow our videos right about now, I beg do well to tell me in the comment section that you are following, because I try to break them down as possible as we can do. Okay, so how will this help Mazi? May I show you something important? Key principle from the Mobile ruling. Supreme Court dismissed the claim because the Federal High Court lacks jurisdiction. Mark this particular word, lacks jurisdiction. Okay, that is the first reason why the Supreme Court squashed that ruling. They can continue by saying, court principle, a court must have a proper jurisdiction to hear matter, or its ruling can be invalidated on appeal. The court held that Federal High Court lacked jurisdiction to hear land-related compensation claims, and it went on and on. So Mazi Nnamdi Kanu needed the Supreme Court to speak on the issue of lacking jurisdiction. He needed this proclamation from the Supreme Court itself when Ingo entered there. Because it's one thing for you to enter the Supreme Court and say, okay, the Federal High Court lacks jurisdiction. The Supreme Court will ask you, how did you know that? Well, this particular stage, Mazi Nnamdi Kanu can quote them using their own laws and arrange them with the way where you go take favor them. Okay? Now we'll look at how does it affect Mazi Nnamdi Kanu's case directly based on that court's rulings where I don't show you, handled by the appeal courts. This principle could be central to arguing that is his arrest and trial may have procedural defects. Certain courts may not have proper authority, and therefore any adverse judgment might be invalidated or overturned. These are 3 key factors where Nnamdi Kanu they outline right about now from these declarations coming from the Supreme Court, as the case may be. Are you guys following? This is the biggest and surprising document where the Supreme Court just released as of today. What about the other case? The other case was held in February of 2026. This one too now something where Nnamdi Kanu wanted to pick something from this case. The first case, he wanted to pick out lacking jurisdiction from that case file. This one now, make I show you wetin Nnamdi Kanu they pick from this other case that the Supreme Court has handled. It states FCT Buhari Area Council primary dispute, 17th February of 2026. In a split decision, the apex court, that is the Supreme Court, affirmed the dissenting judgment of the Court of Appeal and held that Joshua Ishaku was the lawful All Progressive Congress APC candidate for Buhari Area Council chairmanship election. The court ruled that the appellant was denied fair hearing. That they pay attention. The Supreme Court, they say the appellant was denied waiting fair hearing. And now you go to say Nnamdi Kanu is very intelligent. We'll continue. And that the internal party dispute origins did not automatically bar judicial review. So, Nnamdi Kanu and his lawyers are picking something else from this Supreme Court judgment, which is fair hearing. They want to hold the Supreme Court by their own words. The first one, where I don't show you, it's lack jurisdiction. Okay? Now, the one carry this particular statement of fair hearing, that the appeal court did not give a fair hearing to Joshua Ishaku. They don't pinpoint them out. How does it affect Nnamdi Kanu's case directly? Let's go through it. The Supreme Court held two important things, okay? The right to fair hearing is fundamental, very, very important. The right to fair hearing are the foundation of any case. The court ruled that the appellant was denied fair hearing in the Court of Appeal. Very good. Fair hearing is a right, not merely a procedural necessity. Even internal party disputes do not remove access to the judicial review if constitutional rights are engaged. So as you can see, the Supreme Court are speaking. Nnamdi Kanu is taking notes. They speak in they take notes. Nnamdi Kanu is one of the most brilliant and intelligent person in the whole wide world where you go fit know. This man is not just preparing for the appeal courts alone. As in they prepare for appeal courts, in the package himself from the Supreme Court too. Some of you might be like, why is he preparing for the Supreme Court? I don't show you the reasons. But that notwithstanding, there are other things that you need to know. But we'll come back to that in a second. Okay? So now, how does this whole thing, what I just show you now, affect Nnamdi Kanu's case? Like I've said, it's fair hearing and due process. Hold this one tight to yourself. One of Kanu's central legal concerns has been whether his arrest and rendition was lawful, his rights were respected during trial, he received due process at every stage. This is fantastic, and this definitely will go a long way. It will go a long way in the case of Mazi. This man is not just ordinary. In the inside Sokoto State Prison, they organize strong and formidable case file when go present. In they look at the appeal, they look at the Supreme, because if the appeal court says that, okay, the judgment where this man give or Motoshan give is valid, Nnamdi Kanu will still go to the appeal court, the Supreme Court, sorry. Hope you are following. So he wants to use one stone to kill two birds. In they come the appeal court though, but if they don't give declaration when he like, take for instance, if the appeal court squash some of his charges, say they face like he faced about 7 to 9 count charges in the Federal High Court. But imagine say the appeal court can't squash, let's say they squash 6 charges. Can't say you're not guilty on 6. It means say Nnamdi Kanu will still have some years to serve. Maybe, for instance, so maybe 20 years to serve if 6 charges were squashed. Nnamdi Kanu is saying that, 20 years is still be like a life sentence for me. That is why we will still carry everything where they come from the appeal courts. We will still 100% enter Supreme Court. That is why in only prepare documents and they prepare materials. We go assist them and we go help him in this court of law. What do you think of this strategy that he's doing right about now? What do you think of this strategy? Do you think it's too early? Do you think he should wait and focus on one? Do you think he should place all his time on the appeal? What do you think of every single thing? I better go down to the comment section and tell me what you feel. I go there to perceive your idea and react to them when the case or the scenario arises. But what do I think? Well, they say time is of the essence. Time is of the essence. Nnamdi Kanu does not have, in there disadvantage in time. Who the right time? His disadvantage in time. His disadvantage in legal framework. Okay? Is also disadvantage when it comes to, let me write up this framework first. His disadvantage when it comes to the court of law in general, because his case is political. His case is political in all nature. So this man now has disadvantage in 3 vital key points. He no get the time with me and you get. He no get that time. Because the court of law can use multiple years. They can want to spend like 3 years in his case file. And say, if they want to spend 3 years for his case file, he go there inside Sokoto State Prison. He no get that time. So they wait for 3 years and all. And that is why he wants to, since we go, let's call this one the appeal court. Since we come the appeal court to drop documents and argue his case, let's look at the Supreme Court at the same time so that we go save time. We go save time in all ramifications and move with the speed of light. Hope you're following. So by doing so, he's saving his own time and getting everything ready. The legal framework no support, no day on his favor. Now him be his own lawyer. Make I carry his picture come this other page so that we can get the full picture as the case may be. Mukara and come here. So Nnamdi Kanu happens to be his own lawyer. Aloy is going to just be as a counsel. By doing so, he needs every current information where they happen from Nigerian courts, be it Supreme Court or Appeal Court, any court declarations will happen, will favor his case one way or the other. He needs it. Hope you're following. And also, say the court of law no favor him because this man's case is a political case, not just a case between the court of law and him. Some politicians are against his freedom. People no want to see him come outside, they're free. So by doing so, he needs every declaration coming from the court of law. He needs it.
80%, if not 90% of the people of Southeast, the Igbos, they are with Nnamdi Kanu. They know that Nnamdi Kanu is not a criminal, is not a terrorist. I want to commend them. That one is on that. Then secondly, Dr. Bat, you said that you know all that transpired yesterday. I beg to disagree. You don't know all that transpired yesterday. Because what you people, just like Vimbai commended the judiciary for allowing to stream the judgment live. Now you ask yourself, what stopped the judiciary from streaming the trial live so that people will understand what happened? But that one is a different ballgame.
Just a moment. I didn't say that I know what transpired. I was not in the court. When did I say I know all that transpired yesterday? Okay. I just asked you to react to what happened yesterday. I didn't say so.
Okay, sorry.
Yeah.
Okay, sorry.
I was not in open court.
Sorry,
I would have known.
I withdraw it.
Yeah.
Okay, sir. Okay, sir. Sorry, sir. Now, I also want to join, I want to call all well-meaning Nigerians to join hands into this matter so that the Court of Appeal will set aside this judgment. Doctor, but I want to tell you that as at yesterday, when the judgment was given, there in America, where our delegates were facing the U.S. Congress, one of the congressmen now raised this issue. He narrated the kind of injustice Nnamdi Kanu have suffered in the hands of Nigeria, as if the man is a Nigerian. So most of the times when we are talking, these people get information more than you. Let me just start by saying that Nnamdi Kanu has suffered the highest injustice any other person can suffer in the whole world, here in Nigeria, in his own country. One, he was enjoying his bail. A government, the prosecutor, who is prosecuting him, went to his house in Afaruku, unprovoked, and they killed 38 persons and left with 13 corpses as we speak. As we are talking about, as a result of that, he lost the parents. Now, that, as if that one is not enough, Mazi Kanu ran away and deposed affidavit from Israel. My Lord, I'm in Israel. Look at the circumstances that made me to run away. The affidavit, who have it, is in the court file. Please, if my Lord can guarantee my security, I will come back to face my trial. While that one was on, he was unlawfully brought back to Nigeria here. And the United Nations, through their special rapporteur, gave a decision saying that Mazi Kanu never is not a terrorist, Mazi Kanu never jumped bail, that as a matter of urgency, that Nigeria should release Mazi Kanu. They refused that judgment. Federal High Court in Umuahia look at all the whole matters we filed, and they said that Mazi Kanu should be released, and that federal government should pay Mazi Kanu 50 billion naira. As we speak to you, the federal government has not complied with that judgment. The same thing applied to Enugu High Court and what have you. I'm not talking about that of Kenya. Coming back to Nigeria here, we continue with the trial. Then Court of Appeal unanimously discharged Mazi Kanu, and they said that no court should try Mazi Kanu. Federal government refused to comply with that order, and they kept Mazi Kanu unlawfully for 9 days before they now file what they call motion for stay in a criminal matter, the first in history. Now, when they file the motion for stay, the matter gets to Supreme Court. Supreme Court, in looking at all these things, Supreme Court made an decision. One, that Mazi Kanu never jumped bail. The court ought not have revoked his bail. And they condemned the attitude of military, sending Operation Python dance in his house and massacred many people there.
All right.
And they directed the Federal High Court, let me finish, let me make this submission, and they referred the matter back to Federal High Court to continue with the trial, with the intention that the matter will continue with the Honorable Justice Binta Nyako's court. So when we get there, Binta Nyako now recused himself. The matter now get back to Justice Omotosho. Mazi Kanu took a fresh plea. That plea Mazi Kanu took before Justice Binta Nyako is no longer effective. He now took a plea, a fresh plea, in a fresh court, starting de novo.
Okay.
Now that was where the issue of repealed law comes in.
Okay.
Okay.
All right, thank you very much for breaking it down for us this morning. Now, you said as part of your statement that a significant number of people in the Southeast are sympathetic at best to the plight of Nnamdi Kanu. Now, in the interest of public peace, yes, and in the interest of national security, how should this matter be managed, pending when the next decision, whether to appeal or not, will be taken by Nnamdi Kanu? I say this because I believe that at the end of the day, what we want is to ensure that we don't further incite people to aggression or to violence, and that we are able to have some peace in the Southeast. Also, I'd like you to comment on the situation of the sit-at-home order. In terms of that regard, would you ask that people return, or we are hopeful that we will see an end to this Monday sit-at-home order in the Southeast?
Well, I want to start by saying that the issue of sit-at-home, some people took advantage of Mazi Kanu's incommunicado and be issuing unnecessary order. When this issue started, Mazi Kanu personally sent me to Europe to go and talk to Simon Ekpa that he should stop this sit-at-home. I think either in this studio or in another studio, where we also issue that whatever thing that you are doing, Nnamdi Kanu is not a party to it. Lucky enough, one day, the DSSS allowed Nnamdi Kanu to speak from the court. Nnamdi Kanu also made it very clear to everybody. That one is on that. Now, back to your question. The best way to handle this thing is for Court of Appeal to set aside this most embarrassing judgment aside and allow Nnamdi Kanu to continue with his agitation. And let federal government now call him. My brother, why are you agitating? So that, one, because yesterday, in the judgment, you are comparing Mazi Kanu's agitation with Boko Haram. Somebody that told you that, look at what I am fighting for. Look at what I'm fighting for. Instead of you to call the person, what is the problem? How do we feel that we can resolve this thing? You know, I'll tell you, this is what gave rise to this agitation, this is what gave rise to this agitation. Then you address it. The agitation will just die naturally. Now, why the judgment here says because Mazi Nnamdi Kanu is an Igbo? Yes, it's because Mazi Nnamdi Kanu is an Igbo. You can't do it to any other tribe in Nigeria.
No, Maxwell.
I want to
Maxwell?
prove it. Yes, I want to prove it. I want to prove it.
No, I want to just say, wait, hold on. I want to say that it's important that we're able to not incite any form of aggression based on this assertion. So except you're able to prove beyond reasonable doubt, please don't make such assertion.
My people, now don't hear waiting go on. So waiting, I need to talk about the welcome development. I go want to make on a share on a thought at the comment section. Your thought is really needed. You understand? So this case of Mazi Nnamdi Kanu is something where we say everybody need to put hands on decks and try as much as possible to support Mazi Nnamdi Kanu in whichever way we say if you support, whether by finance, whether by speaking good news about Mazi Nnamdi Kanu, because I believe this time around we must go home, because with the facts US don't they put matter for Nigeria matter, and also they go look into what's waiting they go on for our country. So well, I know we just talk much. I go just allow una make una share on our own thoughts at the comment section and drop your opinion at the comment section. Click the subscribe button for more updates. Thank you, my lovely people.